Right. Open Secrets went to court yesterday to oppose the application of Judges Willie Seriti and Judge Hendrick Musi that seek to give immunity to retired judges from accountability. And this was, of course, at the South Gauteng High Court in Johannesburg. Now, they argued that retired judges should be held to account for misconduct that they committed while in active service. And Open Secrets and Shadow World investigations have been insisting that Judges Seriti and Musi must account before the Judicial Conduct Committee for their failure to adequately investigate the arms deal during the commission of inquiry into allegations of fraud, corruption and wrongdoing in the Strategic Defence Procurement Package, which was known as the Seriti Commission from 2011 until 2015. Now, Head of Investigations at Open Secrets, Michael Marchant, joins us now virtually. Michael, thanks so much for speaking to us. Welcome to Morning Live once more.
Good morning, Sakina. Thank you very much for having me.
So we've spoken about this, over the years several times, but just to come to where this is at right now, the complaint focused on the High Court's damning judgment, which found that Judge Willie Seriti and Judge Hendrick Musi had actually failed to properly investigate the arms deal and set aside the report of the commission. So what exactly happened in court yesterday?
So that's correct, Sakina. And just a reminder for that 2019 court judgment that set aside the findings of the Seriti Commission, that judgment was not only saying that the judges had made a mistake, for example, in that commission. It made very clear findings that they had steadfastly refused to actually undertake an investigation, and that they had, in many instances, refused to engage in evidence at all, even when that evidence of wrongdoing in the arms deal had been offered to them. And so this was, I think, clearly of great concern, and that's what prompted Open Secrets and Shadow World investigations to write to the Judicial Conduct Committee in 2020 to say that given the damning findings and the evidence that the judges had failed really to do their fundamental task at that commission, that they should be subject to an investigation. The Judicial Conduct Committee agreed with us and said that the allegations were very serious and that, if proven, may well establish that the judges had engaged in misconduct. And then just on the eve of that Judicial Conduct Committee process starting, the two judges, Judge Seriti and Judge Musi, launched an application in the High Court to say that they were retired and that retired judges should not, under the Constitution, be able to be held account by the Judicial Conduct Committee. And so we saw this very clearly as an additional attempt to dodge accountability by the committee. And so what the judges were doing is engaging in this separate process to ensure that they would not be hauled before and investigated by the JCC. And so what was in court yesterday was our intervention against the judges, their arguments to the court, and ours pushing back very strongly to say that judges cannot simply retire to avoid accountability. The conduct they engage in while in active service is of huge importance to the integrity of the judiciary. And because the JCC thinks that this warrants investigation, that absolutely should proceed. And there's nothing unlawful or unconstitutional about a retired judge being hauled before the JCC.
So let's just look at that a little more closely, Michael. So Judges Seriti and Musi saying that they basically seek to be immunized, or they want retired judges to be immunized from accountability, and stating that they want that to be done in terms of the Judicial Service Commission Act. So what exactly does the Act say about retired judges and immunity?
Well, we think that the Act and the framework that's found in the Constitution is very clear, and that it refers to the JSC Act, certainly refers to judges more broadly, both in active service and after their active service. And what I think it's important for us all to remember as the public is that, unlike many professions. Judges enjoy the benefits of the office in many ways long after they've retired. They, for example, receive a full salary and they receive all of those benefits. But also, very importantly, they often engage in additional judicial functions, such as commissions of inquiry. Those are often led by retired judges. And so when we look at the JSC Act, we think very clearly that it applies to judges both in active service and afterwards. And I think that there are a lot of international legal principles, the Bangalore principles, for example, that say that it's actually very important that acts like the JSC Act continue to apply to retired judges. And the reason for this is that the integrity and the trust, public trust in the judiciary, depends on having mechanisms for accountability for judges that engage in misconduct. If judges themselves are seen to be above the law, even for an arbitrary reason, for example, such as choosing to retire, I think it really risks eroding the public's belief in the integrity and the independence of the judiciary. So we, on that front, think that the law is very clear. We don't see any clash. And we also think that it's fully in line with the principles found in the Constitution, both broadly as it relates to the need for accountability, but also narrowly in terms of the Constitution's understanding of the judiciary and what a judge is.
So, Michael, you also want the Judicial Conduct Committee to consider whether some of these actions by Judges Seriti and Musi may even constitute criminal misconduct. And if so, you've asked for those to be referred to the NPA for further action. So how far has that gone? And has the NPA been roped in any way, shape or form at this stage?
So, Sakina, the reason for that request is that there were two areas of the report in particular where the Seriti Commission indicated in its final report to the public that there was no evidence of corruption in certain parts of the arms deal. In the review application in 2019, the actual documents that came before the court showed that in some instances that was completely the opposite of what had happened, that in some cases evidence had actually been offered. And so our contention is that there is a chance in that instance that it appears that the Commission deliberately misled the public in the final report, and that may amount to fraud. So that's the origin of that request. Unfortunately, what has happened in this instance is by them launching the separate application on the constitutionality of retired judges being held accountable, that has stopped the rest of the process. And so there have been no further hearings in terms of the Judicial Conduct Committee. And our understanding, certainly at this point, is that they therefore would not have made any referral to the MPA, and we have not directly engaged them on this issue. I think what we think is really important is we hope that the courts will be very clear that retired judges are indeed accountable in the JCC Act. That would then allow the JCC to continue with its hearing, and we would hope that it would agree with our contentions at the end of that not only has there likely been misconduct by the judges, but that actually there may be a need for a criminal prosecution, and that the MPA should look at that evidence as well.
So just, looking around, and I know you guys at Open Secrets, you've been plugging away not only at this, but so many other matters where public funds have been squandered, where there seems to have been misconduct, at various levels in the public domain. But there seems to be public apathy, if you will, Michael, on many of these matters, save for civil society organizations like Open Secrets. What do you make of that? And this despite the public outcry on many issues that are reported in the media on these matters?
Sakina, I think that it's a complicated question. I think that particularly when it comes to the arms deal and accountability, what we see is that the ability of both politicians and corporations to dodge accountability for such protracted periods makes it quite difficult for the public to actually remember and engage with what actually happened there and the costs of what happened. We should remember that the arms deal was signed in 1999. That was the first time that evidence of corruption in that deal came to light. And so I think with the rapid news cycle, with all of the contemporary corruption, I think it's one of the reasons that it becomes easier for the public to disengage with some of those issues that are now a little bit past. What I would say that is so important to remember is that in contemporary terms, we're looking at about 140, 150 billion rand that was spent on that arms deal to buy weapons that we didn't need. That money was spent in a moment of great need in South Africa. That money in that period could have been spent, for example, on the HIV/AIDS crisis at the time. At the time that the government was saying it couldn't afford medication, it couldn't afford basic social services, it was spending this money on the arms deal. And so I think it's our job in civil society also to do that reminding, and also to remind the public that this is the perfect instance, is that accountability is a very, very long game. And for those who seek to avoid it, it requires dedication, continued engagement in different forums. And the arms deals, maybe a good example is that Jacob Zuma and Thales, the French arms company, should be appearing in court again this year on criminal charges. This case is going ahead. And that's a testament to the many activists in civil society and different organizations that have kept the pressure up. And I think that once we begin to see some accountability, that's how also, we re-engage the public in the belief that parts of the system can definitely work.
So, Michael, about 150 billion rand spent on the arms deal itself. How much was spent on the commission?
So the commission cost tens of millions of rand in the final calculation, and it is the kind of added, I think, pain of what happened in this kind of situation. Commissions of inquiry do tend to be very expensive. We know, for example, that the Zondo Commission also cost northwards of R1 billion. But I think that what we see with the Zondo Commission, by contrast, is the value that a commission of inquiry can bring to uncovering the truth of what happened and providing a base for other law enforcement agencies and civil society to engage in the evidence. That was the hope for the Seriti Commission as well. I don't think we would have had any concern with the money that was spent on the Seriti Commission if the Commission had shown any interest in actually engaging with the evidence, with whistleblowers and with those who knew what had happened in the arms deal. I think the thing that really stung was the tens of millions that were spent on that when the judges sat back and refused to engage in any of the evidence.
So you've got, as you mentioned, the former President Jacob Zuma and arms company, French arms company Thales. They are currently still going through the courts process. We remember Tony Ngeni and, of course, Shabir Sheikh. But who else has been held accountable for this?
Very few people, if any, Sakina. And it's a good point that you raise. We've spent a lot of time, I think, as the public in terms of the arms deal, focusing on the Zuma-Thales connection. And as a reminder for those of you who may have forgotten, the allegation there is that the giant French arms company, Thales, previously Thomson CSF, the allegation is that they made a number of payments to Jacob Zuma and agreements to pay him to protect him from prosecution for any evidence of corruption in the arms deal. Why that story, I think, is so telling is it shows how these instances of grand corruption are not only about the corruption itself, but they're about how the actors, particularly the corporations that are engaged in that conduct, how they then mobilize their resources to avoid accountability. What we have then seen is that we think that there's enough evidence to proceed with criminal investigations and possible prosecutions of a number of companies from different places. We should remember that these were largely European arms companies that benefited from the deal. For example, British Aerospace, BAE, was one of the great beneficiaries, the British arms company. There has been an investigation in the UK from the Serious Fraud Office, which unfortunately was not seen through to some form of proper accountability for the South African case in particular. And that was some of the evidence that the Seriti Commission ignored. But to go back to that question about, we still think that there remain opportunities for accountability in the South African context, and that it is up, I think, for the MPA to reopen some of those dockets, some of those cases, to look at both the middlemen and the large companies like BAE and others, and see if Thales and Jacob Zuma are not the first prosecution in a number that could be reinstated in relation to the arms deal.
And elsewhere, because some of these international companies obviously are domiciled elsewhere, anyone else being held accountable outside of South Africa?
The unfortunate answer, Sakina, is largely no. And that is also a reminder to us, I think, that South Africa is not as exceptional in many cases as we like to often think, and particularly when it comes to accountability and the lack thereof, particularly for large corporations, South Africa really mirrors the rest of the world in the fact that those corporations often get away from the conduct that they engage with. And so if we look, for example, particularly at the arms deal, there have been very few successful prosecutions of any individuals in the arms trade more broadly around the world, let alone for the arms deal. What we often see is we see settlement agreements. British Aerospace, BAE, for example, entered into a settlement where it did not admit guilt with British authorities and US authorities, but not narrowly for the South African deal, but more broadly for the type of conduct it did in South Africa, which was paying middlemen for access. And so we've seen in those instances a little bit more information, but we don't see any genuine accountability. And again, I return to the point I made earlier, is that part of the reason for that is the incapacity and lack of will within law enforcement agencies, both in South Africa but around the world, and their ability to pursue complex corruption cases and pursue large corporations.
Well, Michael, we'll leave it there for today, but of course continue to keep a beady eye on these developments. Michael Marchant is the head of investigations at Open Secrets, and the organization went to court yesterday to oppose the application of Judges Willie Seriti and Hendrick Musi, who are demanding accountability to Open Secrets of the two judges whom they say failed to investigate the arms deal saga. And the judges on their part are seeking immunity, saying that they are retired judges and as such should be immune. So let us know what your thoughts are at Morning Live SABC.